Thank you so much, Mr. Chair, and I want to thank you also for holding this hearing and inviting these witnesses. This has been an excellent hearing, and I think my first question would be to Mr. Merrill. I've appreciated your testimony, and again, I'd like if you could go back. You've made comments, but could you go back to this issue of dealing with how Title II would violate constitutional principles when we're dealing with uniform bankruptcy law, and we're dealing with vesting substantial discretion in the executive to invoke orderly liquidation authority? Could you give us a summation of that again? I think this is a very important point that we need to understand the constitutional vulnerability. Right.
Well, I'd be happy to respond to that and also respond to a couple of points that were just made by Mr. McTaggart. It's true that most of Title II was borrowed from FDIC receivership law, and that the courts have upheld the FDIC's receivership process, whereby there's an administrative appointment of a receiver, and then the process unfolds after that. The big difference between the FDIC law and Title II is that under FDIC receivership law, an aggrieved party can go to court and ask the court to set aside the receivership and can raise any issue that they want to. Under Title II, there is no review after the receiver is appointed. That's the end of the game as far as stakeholders are concerned, other than ordinary creditors who may get some relief from the FDIC as receivers. So the shareholders, the directors, the officers of the company, who all have to be mandatorily fired under Dodd-Frank, have no way to protect their interests because there's no judicial review before or after under Title II. There is under the FDIC Act. There is not under Title II. Secondly, this local D.C. rule that's been mentioned, the D.C. court was clearly uncomfortable when it looked at this statute. It asked the Secretary of the Treasury to please notify it 48 hours in advance so that they could try to get a judge lined up and so forth. But that local rule can't change the basic skeletal provisions of the statute, which make it a crime to inform most stakeholders that there's going to be a liquidation. No notice whatsoever, which gives the judge only 24 hours between the time he sees the government's petition and the time he has to rule, and which gives the company whatever's left of 24 hours to try to respond and address the issues that the government raises in its petition for liquidation. So the local rule, I think, helps a little bit at the margins, perhaps, but does not address the fundamental flaws, due process, Article 3, and so forth that this statute creates.
And Mr. Merrill, based upon the latter part of your answer, would you classify that as a potential vulnerability under First Amendment grounds?
Yes. I mean, the statute says you can go to jail for 5 years for telling the world that the government's trying to liquidate your firm. That's unprecedented. I know of no analogy that would sustain that, and I think the court, in a proper case where a firm thinks that it's improper to be putting it through liquidation, that there's some kind of abuse. I'm not suggesting there was abuse in the past, but in the future there might be. A firm that thinks the government's trying to put it through liquidation inappropriately, they can't leak this to the New York Times or the Washington Post without having the officers of the firm be chucked off to jail for 5 years. That is an extraordinary incursion on the First Amendment, in my view, and I think the courts would be very uncomfortable with that.
And Mr. Merrill, have you ever seen anything like this before in your history, in your academic life, and in your practical work that you have done? Have you seen any kind of restrictions and constitutional problems in this vein before?
I think this is completely unprecedented. I think you had some interesting models that you could work with. You had the bankruptcy code, you had the FDIC receivership law, and for whatever reason at the last minute, the Senate came up with this novel hybrid which essentially dragoons the court into rubber stamping the executive in this highly expeditious fashion with no notice, no hearing opportunity that's meaningful. And with the stakes being so enormously huge, I mean, we're talking about, you know, all kinds of people having huge financial interests at stake here. I don't think there's anything remotely like it in U.S. law. In fact, you can't, in looking at the Article 3 issue, I couldn't really find any precedents where the courts have been told that they had to rule within 24 hours on highly complicated issues that are very difficult for anybody to figure out in matters of months.
And so then you really do have a denial of due process.
Yes. Potentially, again, when the process is ever used, I think there will be due process violations. And all sorts of stakeholders will have a strategic incentive to raise those constitutional concerns, which will very likely cause the whole process to go off the rails and become, chaotic.
Well, I thank you for your observations because I think they're stunning. And I think, in fact, you've even underscored for this committee how important that is. And I yield back, Mr. Chair.
Gentlelady's time's expired.